All right, let me make sure my mic is working. All right, nope, it's not. Oh, there it is. It's working. All right. What's up? Peace, everybody. It's March the 4th, 4 days into the March already. Seem it just started a few days ago. And as you know, these days they whiz by, before you know it, you're in another month. So if you did the New Year's ritual with me, you guys set up some goals for yourself, right? You got plans. You have good big plans for yourself. And hopefully you're staying focused on that. I understand that sometimes we get distracted, and it comes with the territory. Distractions is what will happen. The most important thing is that you notice the distractions and you get back on track. Some days you're just not going to want to work on that project. Your old self will come out and say, "Hey, I just want to sleep. I want to just watch TV, do something else." So those are the days you really have to be purposeful and fight that and just and do it when you don't feel like doing it. See, doing it when you're in high spirits is one thing, but doing it when you're in low spirits is another. That's what really causes you to make that new project become a habit for you. Doing it in opposition. Because the more you do it through opposition, the more it becomes like second nature. And what seems to be opposition to what was opposition to you before is not opposition anymore. So really, it's about overcoming yourself, not people, things. It's overcoming your temptation to allow your mind to take you off track by allowing outside stimuluses or outside distractions to pull you in that direction. It's really about you. So we had the webinar, 2-day webinar, Saturday and Sunday, and it was a good one. It went. I think it went well. People appreciated the information. So, and I just hope that they take it and start putting it to use. And whenever you get something new, it takes time for it to sink in and just really get your groove going. But just do something. Just do a little bit at a time. Work on just a little bit, and then the next day work on a little bit plus a little bit more, and then the next day work on a little bit more, and a little bit more. Just take it a little further every day. A good book that could help you understand what I am talking about is called Atomic Habits. Teaches you how to take small micro steps towards the bigger picture. So yeah, it was a good turnout. So the next seminar is already on the books. Baltimore, Maryland, of 29th and 30th, and possibly Miami, Florida the following month. But right now, what's concrete is the March 29th and 30th seminar. So I'll get you the details. Hopefully I'll have all of the details by this week so I can go and put together the information and start sharing it. And hopefully I'll see you there. I look forward to seeing all the people. And I also want to thank all the people that joined on that webinar and made it a success. Thank you for for supporting. So today we're going to talk about certification of trust. That's the trust document that you would use when you go into the bank and what by law is required on it. I know some of you, I've helped some of you to uh, with your trust, and then, with that you got the trust plus the certification trust, and you ask the question, oh, what do I need this for? And then I explain it. But that document is written and codified into the statutes on how what should be on it. I've got a few states codes pulled up so we could read that. Then we're going to talk about insurance trust. I thought that would be a good topic to talk about today, because we talk about getting life insurance, but it's another thing when you have the trust purchase the insurance for the benefit of the beneficiaries, and we're going to touch on that, what the benefits of having an insurance trust is. There's so many types of trust and so many things you can do with trust. It just all depends on your situation. This is why I always disagree with people who say, "Oh, you got to have a lot of money to have a trust." Well, everyone talks about getting insurance, right? And once I read to you the benefits of having an insurance trust, how it saves on taxes, I think everyone who's got life insurance can benefit from that information. Because the name of the game is minimizing your taxes, minimize money that you can actually keep in your pocket, keep that money in your pocket versus it going somewhere else and never returning back to you. So we'll talk about that. But before I talk about that, I want to just show you how shiesty these courts are when it comes to men's and women's issues, and how biased these courts are about taking your money from you, hard-earned money, and giving away. So I'm going to read something. I don't know if this story is true. I don't know, but I think it has some truth to it. But we're going to read it. It's about this. I think this guy is a fighter, Israel Adesanya. Adesanyas. I do not know how to pronounce that. Israel Adesanya's ex-girlfriend Charlotte Powdrell cries her eyes out after paying him $500K for taking him to court after their breakup. So here's the deal. Y'all understand why I'm reading this once I finish reading this here. Charlotte and Israel never got married, nor had kids, but when Israel broke up with her, she took him to court demanding for half of his estimated $15 million fortune, arguing that they dated for too long, which was only 1 year, and he ought to have married her. Well, who says she had to marry? I don't know. This entitlement thing. So after following and investigating the case for over a year, the court finally passed judgment that she should be given half of Israel Adesanya's wealth, but it was discovered that Israel Adesanya's net worth is zero, and he has never owned a bank account his whole life. And since she's worth $1 million and significantly richer than her boyfriend, her own money had to be split among them equally, leaving Israel with $500K. It has been alleged that Israel Adesanya's entire $15 million is being managed by his mother, Tawo, and she had been managing his finances since the beginning of his career. The brother is proud of Israel. So went to some court, and they were only dating for a year, and she figured she can get half his money. I mean, this sounds so wild. Is this true? I don't know, but it just helped. I'm reading it because it points to why trusts are important for you. Why you should not have anything in your name, because things like this and other things can potentially wipe you out. If all your money is stuck in an irrevocable trust that you control, but on paper you're broke, you don't have anything. See, when you're creating trust, you're creating a person, another person that you manage and control. and allow it to be able to do commerce for you instead of you actually doing the commerce. That's the key. And I believe everyone can benefit. I don't care what income level you're at. Because last I checked in these courts, most of the people that's in these courts where they're dealing with these domestic issues are middle income to lower income for the most part. Those are the most who's in there. And a lot of these people are getting wiped out through these these types of judgments. So I guess she went and, oh yeah, you get to split each other. I guess the order said you guys have to split each other's estate. I don't know how they came up with that. Like, how did it? 1 year you get to get half of his money and keep going. You no longer have the privilege of being his girlfriend or even potential wife, and you get paid for a breakup. What is that? The reason why they have these judgments, especially if it's in the United States, is because the government pays these states money for enforcing these types of orders. They get benefits from the federal government. This is why you see these ridiculous orders. And then just imagine all the lawyers who got paid from this. This, to me, which is frivolous. But it backfired on her. She ended up having to pay him because he had no money. She looked richer than him. So what's good for him was also good for her. See, the laws is switching up. The reason why a lot of guys get hammered in court is because they don't fight. They don't really respond to the complaints. They just show up in court. Anytime you get a complaint by way of a suit, you need to respond and put your answer on the record. If y'all don't remember anything, anytime you get a lawsuit, I don't care what it is, you have to answer, even in a criminal case. You have to put your actual response on the record, but these lawyers never do this for you. They just go back in the court, talk to the prosecutor, figure out what kind of deal. They don't file any paperwork, but the rule is clear that any complaint lodged against you, you have 30 days to answer that complaint, or you lose by default. This is why most people lose in criminal cases. Because they just show up in court at the first, the second, the third, fifth, whatever appearance without any documentation, any answer, any motions on the record. But once you understand how the rules work, that if someone makes a complaint, you got to respond with a rebuttal, with either a denial or acceptance, or a move to dismiss it for one of the rules of that you would follow for dismissal on whatever grounds you have. Both work the same way, civil and criminal. Because technically, a prosecutor can move for default judgment against you because you didn't respond to that complaint. You get a traffic ticket, you need to be drafting up paperwork and denying that traffic ticket right out the gate. Right out. Most traffic tickets, you have the time to go to court is set right after the 30 days. Why? Because they know you're not gonna answer it, and this is why the judge rendered judgments against you in court. Well, they're not being fair. No, they are being fair because you never took the time to rebut it by way of entering your answer or your response into the record. And see, you can listen to all of these knuckleheads that'll tell you, "Oh, you answer, you're giving them jurisdiction." Here's the problem with that argument: the court has already assumed jurisdiction until you challenge the jurisdiction by way of a motion into the record. they're going to assume that they have jurisdiction. Okay? So you got to take away that assumption by way of a response. Okay? I know I was going to talk about trust, but I want to read something real quick. Trying to give y'all a little education here. Let's see. So you could say something like this: comes down John Doe, spiritual man, appearing specially and not submitting to the jurisdiction of this court in any corporate or statutory capacity. I hereby provide notice that. That's something you could say, right? See, if I was served with some type of criminal paperwork, and they always put the name in all caps, I'm going to make sure that on that entry that I'm letting them know that name that they're using is an ens legis, and then right next to the defendant section, it'll say improperly named, period. And then I'll have, whatever else I got to say. And then you'll see the courts backpedaling all of a sudden. Oh, we're going to put this off. Like in this particular instance, they try to force a court appointed lawyer on this guy. And then they say, you better come back. Come back. When you come back here, you're going to enter a plea. See, I don't let them enter pleas guilty or not guilty. No, first we have to establish jurisdiction before we can enter any type of agreement to anything. And then they find themselves in this loop where they can't get past this. See, the reason why most people get slammed, mostly in any case, spending, especially criminal, because they're not entering the proper responses. Because all of this stuff goes on the record. And if they roll over you and damage your rights, violate your rights, now you go to that Article 3 court and get your remedy. But that's enough on that. Let's pull up my chat window. Where's my chat window at? Why isn't it not pulling up? There we go. It's not what I'm looking for. There. All right. All right, so let's go to let's close. Let's talk about what's required and I'm going to read a couple of states' codes. What's required for a trust certificate, right? I don't want that. So this is North Carolina's section 36C under the and when if you want to look up trust codes, you need to go to the probate section of the codes and statutes of that state, and it'll have everything related to trust. If you want to go ahead and read it, if you want to get knowledge, you can read books if you want to, but these statutes will give you great insights on what the court can and can't do when it comes to certain types of trust and the things you can do. Right? So it says Wow. Certification of trust under 36C 10 1013. It says instead of furnishing a copy of the trust instrument to a person other than a beneficiary, the trustee may furnish to the persons a certification of trust containing the following information. So instead of giving the actual expression of the trust, which is the trust instrument, they call it an instrument, they can give them a certification of trust to maintain privacy, right? And remember what I might have said this, or if I haven't, I'll say this now. When you are dealing in trust, you should have not must, but you should, I recommend that you put in that trust document that your trustee is under a non-disclosure clause, meaning he cannot tell anybody but the beneficiaries, the grantor, or talk about any business of that trust outside of the people that are absolutely necessary to having the information. This should protect you. Okay. You need to have that clause in there. Right? So this is the information it needs to have: the existence of the trust and the date the trust instrument was executed, the identity of the settler, which is also called the grantor or trustor, unless withheld under a provision in the trust instrument. So number 2 says the identity of the settler, unless, like in the trust instrument, says the settler shall remain non anonymous. So that doesn't have to be on there, right? The identity that, like, well, let me go back to that. Number 2, I would have that. I wouldn't identify the grantor or the settler unless it's a church. So because I'm trying to create the connection between the church and the trust to keep the tax exempt status, to have that connection of being an integrated auxiliary. So outside of that, I would keep the grantor private. The identity and address of the currently acting trustee, the powers of the trustee. So number 4 is like when you're registering a car, they want to know what the powers are. And one of the powers a trustee must have in order to register property on the state level, whether it be a car, house, uh, any real property, personal property that you have to register. Say you want to register a car, get its plates and registration. They want that provision in there that says that the trustee has power to buy, sell, and take title to property. That has to be in there. They will not allow the trustee to register that vehicle without it, or update the deed or anything without that. That trustee must information must be on that trust certificate. Okay. The revocability or irrevocability of the trust and the identity of any person holding a power to revoke the trust. 6, the authority of co-trustees to sign or otherwise authenticating whether all or less than all are required in order to exercise powers of the trustee. The trust taxpayer identification number and the manner of taking the title to the trust property. B, any trustee may sign or otherwise authenticate a certificate of trust. C, a certification of trust must state that the trust has not been revoked, modified, or amended in any manner that would cause the representations contained in the certification of trust to be incorrect. A certification of trust need not contain the dispositive terms of the trust. Well, okay, what does dispositive mean? Let's look that up. Let's look it up. We don't like assuming here. We think we know what we're. I think I know. Dispositive means relating to or bringing about the settlement or issue of the disposition of property, dealing with the disposition of property by deed or will, dealing with the settling of international conflicts by agreed disposition or of disputed territories. People, um, that's what dispositive mean. All right, let's go back. All right. A recipient of a certification of trust may require the trustee to furnish copies of those excerpts from the original trust instrument and later amendments that designate the trustee and confer upon the trustee the power to act in the pending transaction. A person who acts a person who acts in reliance upon the certification of trust without knowledge that the representations contained in the certification are incorrect is not liable to any person for so acting and may assume without inquiry the existence of the facts contained in the certification. Knowledge of the terms of the trust may not be inferred solely from the fact that the person relying upon the certification holds a copy of all or part of the trust instrument. G, a person who is in good faith enters into a transaction in reliance upon the certification of trust may enforce the transaction against trust property as if the representations contained in the certification were correct. So basically, what that's saying is if you give them a certification of a trust and then the terms of the trust say something different, the actual trust say something different than what the certification says, they don't match up, they can enforce as if that trust did say it because that's the document you show. So make sure that your trust documents are in line. If you're making any updates, you got to update everything. Okay. A person making a demand for the trust in addition to a certification of the trust or excerpts is liable for damages if the court determines that the person did not act in good faith in demanding the trust instrument. So sometimes these places want to see a trust instrument, the whole thing. So they could be liable if they did not act in good faith. I can give you an example of that. I needed to get opening up a bank account. The bank required a not only did they want the certification of trust, they wanted some other documents that they produced signed in front of a notary. So go to the notary to get it signed, and the lady was asking to see the whole trust. And I said, by no means you're just a notary. You are only to verify my signature, not verify my documents are correct. You're not a lawyer. And she was adamant about that. I said, no, you're not. This is something that the bank wants me to do to get my account open. They just want me to have this notarized to make sure that I'm the one signing this. And she said, no, I'm not doing it because I need to see the whole trust. And so I filed the complaint with the notary board in North Carolina and filed a complaint against that UPS store. A notary's job is only to verify your signature, not to verify your documents. Her job is not to verify the existence of a trust. She was way outside of her. And this is one of those things a person can be held liable for damage if the court determines that the person did not act in good faith in demanding the trust instrument. See that? That's a lawsuit. They pull that on you. This section does not limit the right of a person to obtain a copy of the trust instrument in a judicial proceeding concerning the trust. So sometimes the trust instrument has to be produced because it might be some litigation going on that needs to verify some information pertaining to this particular trust. In transactions involving real property, a person who acts in reliance upon a certification of trust may require that the certification of trust be executed and acknowledged in a manner that will permit its registration in the office of the Register of Deeds in the county where the real property is located. This is what I was talking about, where they want specific verbiage on a trust certificate. The certification of trust need not contain the trust taxpayer identification number if that taxpayer identification number is also the social security number of a grantor. I don't know why anybody would do that, but just in case anyone who's using their social as the tax ID number on the trust, you don't have to have it on that certification trust. However, the trust taxpayer identification number shall be certified by the trustee to the person acting in reliance upon the certification of trust in a manner reasonably satisfactory to that person. And there he is. That's North Carolina, right? So, what else did I have? I know I had California. Well, I'm just gonna. Oh, here it is. Here it is. Here's California's rules. Not as long as North Carolina's, but it's basically similar. It says, except in connection with an application for benefits pursuant to Chapter 422 or 422A of NRS, a trustee may present a certification of trust to any person in lieu of a copy of any trust instrument to establish the existence or terms of the trust. The trustee may present the certification voluntarily or at the request of the person with whom the trustee is dealing. Such a certification must be in the form of an affidavit signed and acknowledged by all of the currently acting trustees of the trust. See, in California, they're a little more specific. They want that trust to be in the form of an affidavit. Contents. A certification of trust may confirm the following facts or contain the following information: the existence of the trust and the date of execution of any trust instrument, the identity of the settler, each currently acting trustee, the powers of trustee and any restrictions imposed upon the trustee in dealing with the assets of the trust, the revocability or irrevocability of the trust, and the identity of any person holding a power to revoke it. If there's more than one trustee, whether all of the currently acting trustees must or less than all may act to exercise identified powers of the trustee. A declaration regarding the situs or domicile of the trust and regarding the law that governs the validity, construction, administration of the trust, the form in which title to assets of the trust to be taken, and a declaration that number one, the incapacity of the former trustee of the trust, including the settler serving as the former trustee, has been determined pursuant to section 3, 4, or 6 of the NRS 163.605. And two, the current acting trustee succeeded to the office of trustee pursuant to section 1 of NRS 163.605. The certification must contain a statement that the trust has not been revoked or amended to make any representations contained to the certification incorrect, and the signatures are those of all the currently acting trustees. Then it has the basically the same verbiage as North Carolina's thing. So operating in trust requires you to keep records, right? So if you might have a trustee and that trustee may not be available anymore, so you need to update your trust and get it notarized. This is where trust becomes a little more work, but I think it's worth it. If you have a co-trustee, something might happen to them where they can't serve as trustee for whatever reason. You have to then go update that certification. You actually got to update the whole trust. It's one thing to have the trust, but then the other thing is you have to stay on top of your current events. to keep it from having problems when you're not around. You see? Keep that in mind. You see? All right. Um, so that is on certification of trust. So let's go to insurance trust, which I think is a very good. When I was looking over insurance trust, I have some notes put in here. And before I go into, and because we're gonna go over these trusts over the coming weeks, right? So here's some legal types of trusts. You got a living trust created during the grantor's lifetime to manage assets. Revocable trust can be altered or revoked by the grantor. Irrevocable trust cannot be changed or revoked once established. Now, I know the very first thing is living trust. Living trust just simply means that that trust was created while the grantor during the grantor's lifetime to manage assets. But you can have a living trust that's revocable or irrevocable. Okay, just keep that in mind. Irrevocable just cannot be changed or revoked once established. Uh, to a degree, right? I don't like the way that's written because it doesn't give the full picture. It cannot be revoked or changed if the expression of the trust or the trust instrument doesn't have any specific provisions saying that it can be changed. Okay, you can put provisions in your trust to say this can happen if this happened. So it's remember, you're the one writing the trust and you can customize it the way it works for your needs. Nothing is hardwired one way because everybody's life is different. Then they have testamentary trust created through a will and takes effect after death. That's a testament trust. Basically, if you have a will, it converts into a trust, and that trust is irrevocable. So whatever that will says, it converts into that's called a testamentary trust created through a will and takes effect after death. Charitable trust established to benefit a charitable organization or purpose. Special needs trust that could be a church. Special needs trust provides for a person with disabilities without affecting government benefits. This is why you set up special needs trust, is because you want that person to be able to qualify for Medicaid and other Social Security benefits by setting up a trust. So you put it in an irrevocable special needs trust. That money doesn't belong to the person with disability. They benefit from that trust, but they don't have any income, so they can qualify for these other things. But you have to keep in mind too is they have look back periods. So if that person owns things, they're gonna want to know, okay, did anything go into a trust within the last 5 years? So you have to plan this out. So if anybody has a special needs situation, you would start taking any assets that's going, whether it be some type of money, annuities, or whatever. You need to get those annuities going to the trust, but you have to wait probably 5 years before that person can actually go and claim those government benefits. That's just a scenario. So do your research on that. Asset protection trust shields assets from creditors and legal claims. Spendthrift trust restricts beneficiaries from accessing or controlling trust funds to protect assets. Totten trust, that's Totten trust, a payable on death bank account that transfers to beneficiaries upon the owner's death. That's usually set up like when you have a bank account and you say who the beneficiary is. That's pretty much what that is. That money to go to wherever the beneficiary is on listed on that bank account. Constructive trust imposed by court to prevent unjust enrichment. Blind trust. The trustee manages assets without the beneficiary's knowledge to avoid conflicts of interest. So they're managing a trust, but the beneficiaries don't know what the trust instrument actually says. Generation skipping trust passes assets to grandchildren or later generations, avoiding estate taxes. Qualified personal residence trust helps reduce estate taxes by transferring a home into a trust. That's the one I was teaching people about, and I've taught you guys about how to you need to put your house in the trust. Uh Insurance trust holds a life insurance policy to minimize estate taxes. So that's what we're gonna talk about tonight. Right? Before I do that, what is the comment saying? Make sure we on same page here. I don't know what the hell these people coming with they. Somebody put? I just tuned in. How do I establish jurisdiction? How do I know which type of court to go to? First you got to give me more information for real, because I don't know what's their situation. But we're not dealing with that right now. All right, so let's go over here. Okay, insurance trust, irrevocable life insurance trust. I thought this was fitting to start with this trust. An insurance trust, commonly referred to as an irrevocable life insurance trust, is a legal entity that owns a life insurance policy for the benefit of designated beneficiaries. It is designed to exclude the life insurance proceeds from the taxable estate of the insured, reducing estate taxes and ensuring financial security for heirs. Now, in this situation, if I was to do a life insurance trust, the beneficiary would be a trust, another trust for those beneficiaries, meaning the money would go into another irrevocable trust instead of going to them directly, because they're going to deal with that capital gains tax if they were to take that money directly in the name of that social. Okay. Key features of an insurance trust: irrevocability. Once established, the grantor cannot change or revoke the trust. The policy must be owned by the trust to keep the proceeds out of the taxable estate. This is interesting because I'm gonna get some more information on this, because when you buy life insurance, they want those. I wonder how that affects medical exams when it comes to life insurance. So this is something very I'm going to dig deep on this. Trustee management. A trustee, not the grantor, manages your trust and ensures premiums are paid. The trustee distributes benefits according to the trust terms after the insured's death, avoids estate taxes. If properly structured, life insurance proceeds are not included in the insured's estate. Helps in wealth preservation for future generations. Creditor protection proceeds in an insurance irrevocable life insurance trust are protected from the creditors of both the grantor and beneficiaries. Gift tax considerations: premium payments made by the grantor are considered gifts to the trust. The crummy letter technique can be used to qualify these gifts for the annual gift tax exclusion. So that's Crummy, or it's spelled Crummey. What is let's what does that mean? Let's look that up. Let's look that up. That's a new one on me. At minimum, a basic crummy notice to the beneficiary should contain the name. That's what it's saying. It's not really giving me. Let's see. Here's the Investopedia says, what is a crummy trust? A crummy trust is an irrevocable trust that allows someone to provide financial assets to beneficiaries without using their lifetime gift tax exemption. By transferring assets to the trust rather than directly to the beneficiaries, the grantor avoids the gift tax and maintains some control over the assets. Beneficiaries then have a time limited opportunity to withdraw the funds. A crummy trust can be an estate planning tool that is used to reduce a donor's taxable estate and transfer wealth to future generations. Oh, that's another. See, that's new. We learn something new every day. I didn't realize. Oh, okay. Where was I? All right, let's go back. This is not where I was. Try to find where I was reading. There we go. Found it. All right. Okay, how an insurance trust works. Creation of a trust. The grantor sets up the ILIT and names a trustee. The trust is drafted in specific terms regarding beneficiaries and distribution. Policy ownership transfer. A new life insurance policy is purchased by the trust or an existing policy is transferred. So you can transfer an existing policy. If an existing policy is transferred, there is a 3-year rule. The policy must be owned by the trust for at least 3 years before the grantor's death to avoid estate inclusion. Premium payments. The grantor contributes money to the trust for premium payments. Beneficiaries are notified of the right to withdraw via crummy notices, but they typically don't, allowing the trust to pay the premiums. Death of the insured. The life insurance company pays the death benefit to the trust. The trustee distributes funds to the beneficiaries according to the trust terms tax free. So if you're going to do that, you better have a successor trustee that can handle this properly. Okay? Someone you can trust. All right? And if I would have set this up, all the beneficiaries would know that it exists, know where the documents are, so that whoever's the trustee, uh, I would probably make, one of those beneficiaries the trustee, and they could be a beneficiary at the same time, so they could handle it. They all would know. Everyone would know about this, so that keeps everybody honest. So benefits of an insurance trust: reduces estate taxes, keeps life insurance proceeds out of the taxable estate, provides asset protection, protects beneficiaries from creditors and financial mismanagement, ensures controlled distribution, prevents lump sum payments to beneficiaries, and allows structured distribution, enhances liquidity, can provide cash to pay estate taxes, debts, or other expenses, avoiding forced asset sales. Back to the point I made earlier about I would have the money go to their trust each, like if I have children, right? They should all have their own individual trust, and that the beneficiaries would be their trust, right? So that means that all of those bank accounts should already be in place. Nothing to after something happens. Now everybody's rushing all of these things because you're gonna list the bank accounts. It goes to the bank account numbers, all of that in the trust. All right. Potential drawbacks. Irrevocably, once created, changes are difficult to or impossible to make. Yes, they can be if you don't structure it correctly. 3-year rule. If an existing policy is transferred, the insured must live 3 years for it to be estate tax free. Administrative costs may require legal and administrative fees for setup and management. Yeah, that's if you're paying a lawyer or whatever. Who should consider an insurance trust? Individuals with large estates that may be subject to estate taxes. Those who want to ensure life insurance benefits are protected and used wisely. So that's anyone. High net worth individuals seeking tax efficient wealth transfer strategies. Business owners who need life insurance proceeds to cover estate liquidity needs. There you have it. So it requires careful planning. I could see that. I could see that. The trust needs to own the life insurance policy. All right. There you have it. What's my chat? All right. So who's out there today? We got Javier's on the line. Yeah, he's out there. Said peace and prosperity. Back to you, brother. Happy Thursday, everyone. I said peace to everyone. Scale Boys, man, I ain't seen you in a minute, my brothers. How you doing out there? Indie Circle said peace, my brother. And this brother had some type of question, but I'm not sure how do I establish jurisdiction? How do I know which type of court to go to? For what purpose? Like, you got to understand, I got to know what you're dealing with, criminal, civil, what you trying to sue someone suing you. You got some legal problems. I don't know. Can't answer that. It's too general. Yeah, help like and subscribe to the channel. We got some people on. Half of the people have pushed the like button. Um, I thank you for those that did. I appreciate the other half. Go ahead and click that like button. See what we're looking like on Telegram. No, empty house. All right, so I hope y'all enjoyed what I just read on trust. Next week I'll pick another one. I don't know which one I'm gonna pick, but I'll pick another one. But the 2-day webinar on trust. Now, I didn't just talk about trust over the weekend. I talked about the passport. I talked about debt. I gave away some stuff to help people with their personal situations. Uh, you can go to akemail.com, akemail.net, and that stuff is up there for you to purchase now. Yes, it's $350, but you're talking 2 days of 10 hours worth of over 10 hours, because we actually went to like almost like 6:45, and then you get to listen to all of the questions. People had a lot of questions. So 350 I think is cheap. And plus you get a template of the trust and trust certification with that. All right. So go there and purchase that. It's put together well because I have it done in a PowerPoint presentation, breaking down stuff. I uh even introduce some scriptural references on why you should be setting up trust and how God established trust here with us on earth, and why we should be operating in ecclesiastical trust in everything that we do. Thank you for all of those that put the thumbs up. Just everybody did, just about everybody but one. Appreciate that. Thank you. All right. I think I did the job tonight. If y'all got anything else that y'all need help with, go to akemail.com, get you a consultation. It's only $50. Remember, it was $97. It's almost half price. Go and get it. $50. Fill up my schedule. I need something to do. And I want to thank all of those that do get consultations that fill up my schedule, because I've been busy over the last few weeks. I can talk to you about pretty much anything that you want to know. You want to talk about spiritual stuff? Let's talk about that. You want to talk about some debt stuff? Let's talk about trust stuff. There's not much that I have not come in contact with. And if I don't know it, I'll tell you. But we can sit there and figure it out. Because this way, I'll show you how I research stuff, how I get the information. Sometimes it's because we're so bombarded with so much misinformation, and we get stuck and realize that the power of our information is right in our hands. We got these things, these little devices. They're powerful, but you just need to know how to use them, right? So, um, give me a second. Trying to find some. All right. With that being said, you guys have a good night. Indie Circle. I might be on the Call of Duty for a little bit. You want to jump on? And tomorrow, if you want, we could probably do another TikTok. You know, I've been thinking about doing a lot more TikToks. Maybe we can do one tomorrow evening if you're available. Just let me know. All right, peace, brother. Peace, everyone. Peace and prosperity, extreme wealth to everyone. Everything's gonna be all right. You're gonna do well. Everything that you have coming to you, you already have. You just got to open up your consciousness and